Okay. All right, I'll start. Good afternoon, everyone, and welcome to today's presentation on housing, Know Your Rights. Today's webinar is funded by a grant from the Connecticut Developmental Disabilities Council. My name is Mike Wilby. I am the Strategic Partnerships Manager at Disability Rights Connecticut, also known as DRCT, and will be today's facilitator. My pronouns are he and him. I am a Black male. I have on black rimmed glasses, and I'm wearing a light blue shirt, navy blue tie with white stripes, and light gray pants. Before we get started, I would like to discuss a few housekeeping items. If you have a question or comment, please use the raise your hand feature and you will be unmuted by the moderator. It can be found in the reactions icon at the bottom of your screen. Please remember to introduce yourself before you speak. If you want to hear the meeting in Spanish, please click on the interpretation icon at the bottom of your screen and choose Spanish. There will be a real-time captioning in English. There will also be live captioning and interpreters providing in the following languages: American Sign Language and Spanish. Make sure you're in speaker view. If you're experiencing any difficulties accessing any of these accommodations, please put a note in the chat and we will respond as soon as possible. Finally, if you have a general question, please send it to the chat box as well, and we will try to respond to it. I would like to begin today's presentation with a land acknowledgement. For those who are not familiar with that, a land acknowledgement is a formal statement that recognizes and respects Native peoples as traditional stewards of lands. The statement highlights the enduring relationship between Native peoples and their traditional territories. The statement that I'm about to read comes from the University of Connecticut's Native American Cultural Programs. By acknowledging that the land on which we gather is the territory of the Mohegan, Mashantucket Pequot, Eastern Pequot, Scotticoke, Golden Hill Pagaset, Nipmuc, and Lenape peoples who have stewarded this land throughout the generations. We thank them for their strength and resilience in protecting this land and aspire to uphold our responsibilities according to their example. Thank you. Our speakers and presentations for this afternoon are Debbie Dorfman, Executive Director for Attorney and an Attorney for Disability Rights Connecticut. Debbie will be discussing fair housing rights. Next will be Kathy Flaherty, JD and Executive Director for Connecticut Legal Rights Project. Kathy will be discussing tenant rights and evictions. Our final speaker will be Bonnie Roswick, JD and Director, Disability Rights Project, Medical and Legal Partnership at the Center for Childrens Advocacy. Bonnie will be doing a reminder on utilities. At this time, I'd like to go ahead and turn things over to our first presenter, Executive Director and Attorney for Disability Rights Connecticut, Debbie Dorfman. Debbie?
Thank you, Mike, and welcome everybody. We're very pleased to have you here today to talk about your rights in housing. And as Mike said, I'm going to be focusing on fair housing rights with a particular emphasis on the rights of people with disabilities under federal and state fair housing laws, with a particular emphasis on federal law. So I have a PowerPoint, and so one of my colleagues will be putting that up on the screen in just a moment. So, Priscilla, are you able to do that? Thank you so much. Can you move to the first slide, please? Thank you. So, as I said, we're going to start with talking about, we're going to be talking about fair housing law. And first, just want to go over, you can go ahead and go to the next slide, please, to give you a little overview of what we're going to talk about today with respect to fair housing. And so there are three main federal laws that pertain to fair housing that we'll talk about today. First is the Fair Housing Act amendments, and that is the main federal Fair Housing Act. And then we'll also talk about the Americans with Disabilities Act and Section 504 of the Rehabilitation Act of 1973, which are also federal laws that are similar but a little bit different. And we'll talk about those briefly, along with talking about Connecticut state law. Next slide, please. So let's first start talking about the Fair Housing Act, and we'll call it FHA for short. There's a lot of acronyms, so hopefully that won't become too confusing, but the FHA stands for the Fair Housing Act Amendments of 1988, which is, again, federal law. And so federal law under the FHA prohibits discrimination on the basis of a number of different types of things. One is race, color, national origin, religion, sex, including now gender identity and sexual orientation. That is new under the federal guidance following a fairly recent United States Supreme Court case. It wasn't the case previously. And as well as familial status and disability. Next slide, please. And in terms of how, like, housing providers who are responsible for complying with the Fair Housing Act, really most housing providers are covered by the Fair Housing Act, and that includes housing providers that receive public funds, and also a number of privately funded housing providers. There are some exceptions though, and so it's important to know about those exceptions. One exception, and sorry about the background noise, the one exception is housing owners who have no more than 4 units. So if you are in a sort of small apartment complex, for example, and there are no more than 4 units, then the federal fair housing laws do not apply. But if there are 5 units, they do. Then also single family homes that are sold or rented by an owner without an agent also are exempted, as well as housing that's operated by religious organizations and also private clubs that have housing where only members of the club can use the housing. So if there's a private club, but they have a housing where they allow members of the public to use, then the private clubs are not exempted. So next slide, please. So what are the kinds of things that are prohibited by the Fair Housing Act? You may be wondering about that. Well, one of the major areas is the refusal of a landlord or a property owner to rent or sell property to a person who is protected under the Fair Housing Act. So any people who fall into the categories that we just went over are people who are protected by the Fair Housing Act. And so a refusal to do things like, for example, refusal to sell property to a person because they have a disability, or because they are a person of color, or because they don't speak English, that's illegal under the Fair Housing Act. Similarly, it's also illegal, for example, to decide to evict a tenant. So a landlord can't evict a tenant because the person has a disability. Let's say that the person has a mental health disability and the landlord decides they don't like people who have mental health disabilities. They can't decide to evict them because of that reason. So that's illegal discrimination under the Fair Housing Act. Another example of what a landlord or a seller of property cannot do is they can't have different types of qualifications for different groups of people. So for example, if there are different rental qualifications for a person with a disability than for a person without a disability, that would be discrimination. Also, certain sources of income. So for example, if a person is using federal or state housing benefits to pay for their rent, they can't be discriminated on the basis of that. And that would be like, for example, Section 8 housing. And there could be other types of discriminatory actions that are not allowed. So here's some more examples. So one thing that landlords sometimes do is they have discriminatory advertising. And you might wonder, well, what's that? And so sometimes, and I've actually seen this in some of my own cases, where the landlord will say something in the advertisement that says like, people who don't speak English are not allowed to apply for an apartment, or somebody who has Section 8, their voucher won't be accepted. Those things are illegal. I also want to point out that any sort of misrepresentation is also illegal. So, sometimes, and, I have also seen this in my own experience when I've done these cases, is where the landlord will advertise, for example, that they have 3 apartments available, but then if a person comes and they don't like the way they look, they may not like, if they don't speak English, or that they have a disability, and all of a sudden the landlord says, oh, I'm sorry, my apartments are all rented. And then they turn around and, rent it to somebody else. And so that would be illegal as well. There also cannot be, under the Fair Housing Act, there can't be discrimination in mortgage lending. So, similarly, if a person with a disability wants to get a mortgage and applies for a mortgage, they can't be denied the right to have a mortgage because they have a disability. Also, under the Fair Housing Act, harassment is not allowed, and also retaliation and threats. So, you may be wondering, well, what does that mean? So if a person wants to enforce their rights under the Fair Housing Act, they have the right to do that. And we're going to talk about how to do that in just a few minutes here. But if you, for example, feel that you've been discriminated against in your housing because you have a disability, because of your race, because of, what language you do or don't speak, or because you have a large family, or you're living with a person with whom you're not married, any of the protected categories that we talked about earlier, you can't be retaliated against or threatened because you enforced your rights. So if you file a complaint with the federal government, or you file a lawsuit, if the landlord or the property owner or the person selling the property then decides to retaliate against you, that would be illegal, and that would violate the Fair Housing Act. And certainly, similarly, if the landlord made threats, for example, you better not file a complaint, or I'm going to evict you, or something like that, or then that too would be illegal. And it's, in terms of harassment and threats and those kinds of things, sometimes those also become criminal matters or other civil violations under state law as well. And we'll talk about a little bit about state law in just a bit here. But these are just all examples of things that are illegal. Now, next slide, please. We're going to now kind of focus on what are the rights of people with disabilities under the Fair Housing Act. And it's important to first understand, so under the Fair Housing Act, who is a person with a disability? Well, a person under this law who's considered to have a disability is somebody who has either a physical disability or a mental health disability or other impairment that what the government says substantially limits one or more of the person's major life activities. And so you may be wondering, well, what's that? So a major life activity is pretty much any activity that you need to do to live, including breathing, for example, or might be speaking, might be hearing, might be ambulating. These are different major life activities that would qualify a person, if if somebody has a disability that affects one of those types of activities, that person would be considered to have a disability under the Fair Housing Act and would be protected under this law. And a couple of things that are important to know for disability discrimination in housing. So there's, of course, the types of discrimination that we talked about, like threats and retaliation and sort of what we would call intentional discrimination. But there's also times when a housing provider might not intend to discriminate, but they discriminate anyways. And so that would be, for example, if a person needed some sort of a reasonable accommodation or modification so that they could have equal opportunity to use and enjoy their home, but the landlord or the property seller refused to do that, maybe not intentionally, but maybe because they thought it was too expensive or had some other reason that wasn't because they were necessarily trying to discriminate against somebody. And that is still discrimination under the Fair Housing Act. And so I'm going to talk now a little bit about what is a reasonable accommodation under the Fair Housing Act and what is a reasonable modification, because under federal fair housing law, the two things are different. So let's start out with reasonable accommodations. So you may be a person with a disability who needs some sort of change in a rule or a policy or some practice, for example, by a landlord, and whether that's a landlord in some sort of public housing or publicly funded housing, or it may be a landlord who is a private landlord who has, for example, there's, often big apartment buildings or apartment buildings with multiple units, and the person with a disability may need to have some sort of change in a rule or policy or practice that the landlord is imposing in order to be able to have equal opportunity to enjoy their home or have an opportunity to have a home in the apartment building. So some examples would be, let's say that a person with a disability needs to have a service animal. And the apartment has a rule, the apartment manager or leasing company has a policy that says no pets are allowed. Well, that's going to have to be one of the things that they're going to have to discuss with you if you need a service animal in order to have an equal opportunity to live in an apartment in that apartment complex. Then they may need to change the rules and let you have a pet. And some other examples are, for example, maybe they require a person to submit an application for an apartment through a computer. But what if, because of your disability, you're not able to use a computer? And so then you can ask for a reasonable accommodation, which would be like a change in the rule on how to submit the application, or even changing the time of the month when a rent check is due is also considered a reasonable accommodation. One of the things that's really important and is that, and this is true for both reasonable accommodations and reasonable modifications, which we'll talk about in a second, but each request is an individualized request. And so it's just important to know that, and it really depends on an individual person's situation, and that's really how it should be viewed. One size does not fit all, and that's really important to remember. These are just examples that I'm giving you of possible reasonable accommodations in terms of possible changes in rules, but each thing is really an individualized determination. One other thing that's important is that housing providers can't charge you extra fees because you requested a reasonable accommodation. So, for example, let's go back to the idea that you want to have a reasonable accommodation in how to submit an application. And a lot of times when you submit applications to live in an apartment, there's a application fee Sometimes it's $25, sometimes it's $50, and they apply that to everybody. But what they can't do is say to you, well, you won't submit the application through a computer like we want you to, and we're going to let you do it on paper, but we're going to charge you 50 extra bucks. So now, instead of a $50 application fee, guess what? We're going to charge you $100. That's illegal. So they can't do stuff like that. Also, a person can ask for a reasonable accommodation at any time. It doesn't have to be necessarily when you're applying for the apartment. I mean, people's situations change, people's needs change all the time. And you may start out requesting one reasonable accommodation, and your situation because of your disability might change, and you might need another type of accommodation later. So it's okay to ask for that later on. That's a little bit about reasonable accommodations. Now we're going to talk about a reasonable modification. And so you might be saying, well, what is that? Sounds like accommodation, but it's not the same thing, not under this law. And so what that is when you need a physical change to your apartment or to your house, or some, like, for example, maybe you need to have a parking spot that's closer. So there's a number of physical changes that might need to be made in order for a person with a disability to be able to have equal access to their home and enjoy it just like everybody else. And so that could be, and here's some examples here, a ramp to the front door, modified bathrooms, a modified kitchen. I once had a client who had a floor that was very, very loud. And every time she rolled her wheelchair on the floor, or in fact, anybody walked on the floor, it squeaked so loudly, it was excruciating and really exacerbated the person's condition. And so the person had to get the floor fixed. So there are a whole number of different types of modifications. And just like we were talking about with reasonable accommodations, what is a reasonable modification is an individual determination. And so, again, one size doesn't fit all. It's really about what the individual needs and, what will be needed to accommodate their disability. Under the Fair Housing Act, a person with a disability can be required to pay for a reasonable modification to the home. So you should know that. That is different from under Section 504 of the Rehabilitation Act of 1973. But I will explain that a little bit more when we get there. Next slide, please. So if you ask for a reasonable accommodation or a reasonable modification, you should get a decision promptly. They shouldn't be, dragging it out for months and months and months. They might ask you for some more information, and that's okay. If they need more information, they should come back to you, but they should do it promptly. So if you put in a request for a reasonable accommodation or modification, let's say June 1st, they need to get back to you within a few weeks. They shouldn't be waiting, and the next time you hear from them is Christmas time. Like, that's ridiculous. That's way too long. Also, if they deny your request for either an accommodation or modification, they can do that, but only when it's when the request is legitimately something that there's not a nexus to the disability, and so not really a reasonable accommodation or modification, or if there's, for example, an undue financial burden that it would cause on the landlord or the property owner, or some sort of administrative burden, or some fundamental alteration of like the structure of the building that would cause, for example, the building to fall down, or to seriously alter something that would be just a fundamental difficulty to make that alteration. If that happens and they decide to deny your request, that denial does need to be prompt. Just as I was saying earlier, the decision has to be prompt, has to be in writing, And what's also really important, and I can't emphasize this enough, is it's not enough to for the landlord or the property owner to say, oh, sorry, no, bye, we're not going to talk to you anymore. That is not how it works. What has to happen is if they deny a request, they have to go through what we call the interactive process. And this is really important to remember because a lot of people, a lot of landlords don't remember this, and even though it's their responsibility. And what the interactive process is an opportunity to sit down with the person with the disability, preferably face-to-face, if that's something that, with COVID, it might have to be over video or perhaps over the phone for health safety reasons. But generally, in the absence of a health safety reason, it should be face-to-face, where even if the landlord or the property owner cannot provide the modification or accommodation that's requested, they should try to work with the person with the disability to come up with an alternative that might work. And that requires really a conversation. And so that's what the interactive process is. And the failure to engage in the interactive process is a violation of the Fair Housing Act. So that's really important to remember. And to, like, if you're asking and you're getting a response from the landlord and they're just, saying, sorry, no, and we're not talking about it anymore, then you'll know that that's a problem, because they really should be sitting down and discussing it with you. Next slide. And I know that we're picking up too much time already, so I'm gonna, just kind of quickly go through the next things. I wanted to just also note, as I said at the beginning of the presentation, there are other federal laws that apply to housing. One of them is the Americans with Disabilities Act. There is something called Title II of the Americans with Disabilities Act, and that applies to public housing or to contractors who contract with a town or a state government to provide housing. So for example, sometimes there may be a housing provider that, for example, where I used to live in Washington State, we had something called tiny homes, and there were providers of tiny homes that were contracting with towns to provide the tiny homes to people. And so they had to comply with not only other laws, but also Title II of the ADA, because they were working with the with the local government. There's also, under Title III of the Americans with Disabilities Act, private housing providers have to comply with the ADA in areas where there's public access. So for example, if you are renting, let's say you rent an apartment and there's a clubhouse at the apartment where there's like a pool table, or there's the leasing office, or just the hallways that are the common areas, all of those, there has to be compliance with the ADA. There also has to be compliance with the ADA in terms of providing equal access to the application process, paying the rent, or if it's a condominium, paying homeowners dues, those kinds of things. So those are some examples. There's also Section 504 of the Rehabilitation Act, 1973, which applies to entities that receive federal funds and prohibits discrimination on the basis of disability for those individuals. And then there is, of course, Connecticut has its own fair housing law that prohibits discriminatory housing practices. And Connecticut's law, by and large, well, it does adopt all of the fair housing laws and provides at least all of the same protections. And so that's important to know. Just because of the interest of time, I'll just go to the next two slides and just note a couple of things. If you feel your rights are violated by your landlord or by a mortgage lender or a property owner, any sort of violation in housing that you think may have occurred, you do have rights. You can file an administrative complaint, and you can also file a lawsuit in state or federal court. And so on this slide, I've provided you with the information and the links to filing a complaint. You can file a complaint with the United States Department of Housing and Urban Development. That's called HUD. And for information on how to file a HUD complaint, I've given you the link here. There are some housing in rural areas where you actually would file the complaint with the United States Department of Agriculture. I know that seems strange, but it's true. But HUD can help you figure out whether you should file your complaint with them or go to the USDA. Also, you can file a complaint with the state of Connecticut Commission on Human Rights. They have a special housing discrimination unit, and I've given you the link to that. Just be aware that there are deadlines for you to be able to file complaints. So for HUD complaint, you have to file within 1 year of the last date of discrimination. And for the state of Connecticut, you have to file the complaint within 180 days of the alleged discrimination. And then finally, on the next slide, and this is my last slide, I've also provided you with some additional resources in case you think it's helpful. You can go to the HUD website, and they have a lot of really great information on what your rights are in terms of fair housing. Also, you can go to the State of Connecticut Commission on Human Rights. And also, if you need help understanding your rights or reading more about what your rights are, really encourage you to go to the Connecticut Fair Housing Center. And I've provided you with their contact information as well as their website, and also have included a PDF on disability rights that they've published. They have a lot of wonderful publications. And finally, of course, you can always call Disability Rights Connecticut. That's us. And we're happy to talk with you and to provide you with information and self-advocacy resources. And in some instances, we do provide assistance in housing discrimination cases. We do not handle any eviction cases, however. And with that, I will now turn it over to my colleagues, Kathy and Bonnie. Thank you.
Thank you, Deb. This is Kathy. I'm the Executive Director of Connecticut Legal Rights Project, and I also have a very few slides to share with you, so I'm hoping Priscilla can call those up. So I'm going to give a very abbreviated overview of some general tenants' rights. And the idea behind this is to give you a starting place, but it is not going to be a very detailed overview simply due to lack of time. Next slide. So it's really important to understand that you have rights as a tenant. One of the most important things I want people to know is that a lease does not have to be in writing. A lot of people assume that if they don't have a written document, that they don't have a lease. But you do have a lease because it's any agreement between a person who owns property and the person who rents property that you're going to pay a certain amount of money to have that space be yours for a certain amount of time. Connecticut also provides what's called a grace period to pay your rent. If your lease says that your rent is due on the 1st of the month, under Connecticut law, you have a 9-day grace period, which means really your rent is due on the 10th of the month. And as long as you pay your rent by the 10th, you have paid it on time. You have certain responsibilities as a tenant, and those are things like keeping your apartment clean from clutter, maintaining appliances and using them safely and responsibly. The landlord has the requirement to maintain any appliances. So if you need repairs, that's going to be on the landlord. It's really for a tenant keeping areas that are within your exclusive control in good shape. But if you live in a multi-unit building, you are not responsible for any of what are called common areas. So if you have a shared porch, if you have a shared driveway, those are things that the landlord is obligated to take care of. If you have a shared basement space that's not exclusively yours. And Bonnie may mention some of that when we talk about utilities. Next slide. The most important right that a tenant has is the legal right to what is called summary process, which is the court process of evicting a tenant. A landlord is not allowed to change the locks on you. A landlord's not allowed to just kick you out. That law applies to sober housing. There are certain limited exceptions to the rules for summary process, but if you do not fit within the exception, the right you have is the right to be taken to court if the landlord wants you to leave. And you get to stay in your housing until a judge makes an order that you have to go. Next slide. I'm not going to talk through all of these papers today because we don't have time, but I want people to know what these documents are so that if you come across them or someone you know comes across them, you will know what they are and you will suggest to people that they get help. I'm noticing in the chat, will you get a copy of this presentation? We will be sending out an email afterwards with links to the PowerPoints and other resources that we have for you. So the answer to that question is yes. A pre-termination notice is the first notice somebody might get, and that's a letter. It could be very short. It could be 20 pages long, depending on the law firm that writes it, saying that you are in violation of your lease. That is just the first step in the process, a very early step. And the thing to tell you is that the sooner you call to get help, the more options you will have. If you wait till the end of the process, it will be harder and harder for you to do what's necessary to be able to stay in your apartment. A lot of people leave when they get the notice to quit possession because that paper sort of seems to hint that that's what you have to do, because it tells you that your lease is terminated and asks you to leave by a certain date. But all it really is a request by the landlord to leave by a certain date. And if you don't go, the only thing the landlord can do is serve you that next paper, which is a summons to go to court and a complaint where the landlord outlines what they're complaining to the court about and why they want you out. If you don't respond to the papers, you might get that motion for default. If you ignore that, you will get a notice of judgment, and that will be a notice from the court saying you lost. If you've worked out some kind of agreement and you have agreed to do certain things, whether that's pay back money that you owe or start complying with your lease, and then you don't do that, the landlord doesn't have to start the process over again from the beginning. They can file that affidavit of noncompliance with the court. And then the very last paper is the summary process execution. That's what it's called. When a marshal comes to your apartment, physically removes you and your family from the apartment, takes your belongings out of the apartment, brings them to city storage. And if you don't make arrangements to get your belongings back, the town can auction them off. This is a process that can take months. But if you don't respond to any of the papers that you get, it could take as little as a month from start to finish. That's if everybody moves everything along as quickly as it can possibly go and the person doesn't respond. Next slide. Defending yourself in an eviction is a really important thing to do. You don't necessarily need to do it on your own, but you can. The important thing for you to know is that it started this year, so it was really passed last year. Connecticut started what's called a right to counsel program for tenants facing eviction. That means people have the right to a lawyer, but because we don't have enough lawyers for everybody who's getting evicted, it has rolled out in certain zip codes in the state. I've included in this PowerPoint the link to the website, which is evictionhelpct.org. And what it will ask you for is, first, if you're a member of, if you ever served in the armed forces, because the Connecticut Veterans Legal Center is providing lawyers to any veteran who's getting evicted. Next slide. If you haven't served in the armed forces, you might be eligible for the program if you live in certain zip codes. Right now, the program is operating in about 10 to 12 zip codes, which includes at least one zip code in Connecticut's largest cities and towns, and some in Eastern Connecticut, and some possibly up in Northwest. And if you live in one of those zip codes, you may qualify to get a free lawyer through the Right to Counsel program. I've included in the slide the phone number, and it's a toll-free number. It's 1-800-559-1565, and they will screen you for eligibility at that number. Next slide. So what happens if you don't live in a right to counsel zip code? And I will tell you, there's a lot of zip codes in Connecticut that are not covered. If you're a person who's low income, you can call Statewide Legal Services of Connecticut at 1-800-453-3320. And they will provide you information and advice about how you can represent yourself, or they may also be able to refer you to one of the local legal aid offices for additional help, because they are still representing people who don't live in right to counsel zip codes if you fit within the priorities of their programs. And Connecticut Legal Rights Project represents people in evictions. We focus on representing people who are eligible for mental health services from the Department of Mental Health and Addiction Services. And if the reason for your eviction is related to a psychiatric disability, you can call our office. And our toll-free number is 877-402-2299 or 781-0410. For other people who put questions in the chat, they will be addressed at the end. We are leaving time for questions. And I think that might be my last slide. In which case you can also keep me up and bring up Bonnie to talk a little bit about utilities. Hi, Bonnie.
Good afternoon, Kathy, and thank you for that really very important presentation. And one of the reasons that that so connects to utility issues is that another barrier to keeping your housing is lack of access to utilities. If you live in any kind of public housing, even if you live in state housing, you generally will not be able to stay in the apartment if you don't have lights and you don't have heat service.
Thank you for that, Bonnie. So many of the people I talk to are really stressed out about their utility bills, and they're worried that they're going to get their service cut off or that the bill they're supposed to pay is too high. Can you tell us if there are any payment plans out there that you think people actually can afford?
So what's really interesting about the state of Connecticut is that we have more programs and protections around getting utility service, particularly when you're on a limited income, than many other states. The problem has been that people don't always know about these programs. They can be very complicated, but I'm going to give you some very simple information today to hopefully at least start that process of everybody understanding. The sort of bottom line, which I think is new to a lot of people, is that energy bills, so heat bills, light bills, should be something that you are able to pay regardless of your income. The advocates have been at the state and saying, we can have all the programs in the world, but if you have very limited income, if you're on disability or SSI, and you can't afford what the utility company is telling you, then that doesn't help you. So your monthly bill has to be something that you can afford. And I'll, repeat it at the end, but if you are given a payment program that you cannot afford, you have the right to push back. You have the right to say to the company, but wait, I don't have the income to pay that. And there are places you can call to complain. But to get back to your question, Kathy, there are two major programs in Connecticut that are pretty affordable, and they're broken down between lights and heat. For heat, there is something called the matching payment programs. And what those programs say is that all you should have to pay every month is what's called your average monthly bill. And that means how much, what your new bill is every month, not the amount of money that you weren't able to pay in the past, but the new amount that you use every month. Beyond that, if you are someone that receives state or federal benefits, so if you're on Husky or SNAP or disability or any of those programs, your monthly heat bill should only be $50 a month. And when you call Eversource or CNG or Southern Connecticut Gas and explain that you are a person who's struggling paying their bill, they are required to offer you that program. The other program is around lights, and they each UI has one name for it and Eversource has another name for it. And actually the names are changing so that, the branding will be, people will understand it. Because again, a lot of this over time has been people just don't understand what the programs are. The utility companies talk utility company speak, and nobody understands what they're talking about. So the traditional program is what's called New Start. New Start is a program where you pay your average monthly bill. So if you use $50 every month in electric service, that'll be your new bill. If you have a back bill, then and you pay your new bill every month for a year or for 12 months, your back bill will be paid off by the company after a year. So those are the programs. There are some requirements.
Can you tell us what those are? And
Absolutely. So for both programs, you have to be, it's not enough just to tell the utility company that you're a person who has financial challenges. You have to provide information to them that shows your limited income. So it can be your food stamp budget, It can be your SSI paperwork. And the trick has always been getting it to them. Once you tell them that you are, have limited income, they are supposed to temporarily put you on this program for 60 days, but then within the 60 days, you have to get the information to them. And you're able to do that by US mail, by some of the companies allow email, and the other way to do it is to go to what's called the community action agencies, and there are different agencies in each city of the state.
One last question, Bonnie. Can you tell us where people can go for help if they have really large back bills? Like what organizations might be available to help them?
So again, happily in Connecticut, and again, programs that people don't really know about there are two programs where people can get help. One is called what was known as energy assistance. And this is money that is actually from the federal government that goes to the Department of Social Services, that then goes to these local community action agencies. And the larger community action agencies are CRT in Hartford, NOW in Waterbury, HRA in New Britain. And when you call the utility company, they are supposed to give you the name of your appropriate company, or you can call 211 for that information. But energy assistance is money towards your back heat bill. And this year it was a lot of money. It was between $700 and $1,000. So it can be a real support. The other thing, however, and it's really important to know, is that in order to successfully stay on that $50 a month matching payment program, you have to get this energy assistance. Even if you make your bills payments every month and you don't get energy assistance, they are going to not let you remain in the program. I believe that we have until June 31st to sign up for that program, just because of COVID and all the issues that have come up. But it's really important to get on those programs now. The other great program is, oh goodness, it is very late, my apologies, is the Energy Assistance Program. I've created a really brief couple of slides that should just go through all this information. But energy assistance is also for back electric bills, and they can give you money towards those back bills. I know we're running short on time.
Yeah, I think we'll share those. Questions. Yeah,
Just
we'll share those slides in the post.
Great. My very
email.
last comment is that anybody who calls the companies should really understand what they're saying. And if the customer service reps talk very fast, it's a lot of information. It's very confusing. Make sure you understand what they're saying. And if not, please call and I can assist you with those calls. Thanks very much, everyone.
Now we'll turn it over to Kaylee or Mike to ask questions during the time we have remaining.
Yes, Kaylee, could you look at our chat box and go through some of the questions? And if we can't get to all of those, we'll make sure that we get those answered after the webinar.
Sure, just scrolling up. So one of the first questions we got, Tanya asked, what are the rules around emotional support animals? If we could just super briefly get an answer to that.
Sure. Emotional support animals are covered by the Fair Housing Act. They're not covered by the Americans with Disabilities Act. But if you live in a building that's covered by the Fair Housing Act, you can request an accommodation to have an emotional support animal where you live.
Thanks, Kathy. Tony Phillips asked, if a condo complex has assigned parking and no nearby accessible parking to the person's unit, the person's assigned parking is far away, what might be considered a reasonable accommodation?
This is Kathy again. A reasonable accommodation can include a space that is closer to your unit, that's designated just for you, even if it doesn't usually have assigned parking. That's the whole point of accommodations, are doing things differently than the usual way of doing things.
Thanks, Kathy. Carol Boggs Bernier, I'm sorry if I am saying your name wrong, added saying, similarly, if there is no assigned parking and there are not enough handicap parking spaces near their apartment, is that something they can request?
Yes.
And Tony had another question. If a public housing complex is planning to repave, seal the sidewalk / driveway, and there is a longtime resident with multiple chemical sensitivity who requires an accommodation for materials that should not be used, could that be a reasonable accommodation? There are a few questions in here. Could that be a reasonable accommodation? Should the complex consider using alternate materials for the entire project, or perhaps just part of the project near the unit? What might the management be required to do?
The tough thing with any of those are that the word reasonable is included in the statute. And what often becomes a point of contention is what a tenant might consider reasonable and what the landlord considers reasonable may be two very different things. It's certainly something that could be requested. And then there has to be that interactive process going back and forth. But it may be if the less or the materials that would be better for the person with the disability are significantly more expensive, cost becomes a thing, because if it's an undue burden or it's unreasonable, that might not, that excuse me, that may be a challenge. So I would just say, make the request, and then you can certainly reach out to either DRCT, Connecticut Fair Housing Center. It may require making a complaint, and just know that the legal process moves very slowly.
All right, I'm gonna read one more question, and I know we're going through these quickly. So again, I just want to invite everyone, you can contact us at DRCT directly if you have more questions, or Connecticut Fair Housing Center. And we will provide that contact information in the email afterwards. The last question I have is from Nina. I have a child in a group home and we have no rights, nor does he have a voice. We are wondering if we can construct a granny pod on our rental home, or maybe our own home. Will DDS, Department of Developmental Services, cover our son with an aid? And will DDS pay for what it is paying to the group home now? We need to have a camera and security system for this place.
This is Kathy. I would ask if Deb can contribute the answer to that. CLRP represents people who get DEMIS services, not DDS.
So it's a complicated answer, and it's, I mean, first of all, in the group home, the individual, your son would have rights under Title II of the Americans with Disabilities Act, and probably also Title III. So what I would recommend is contacting DDS and talking to them and seeing what other types of funding that they could provide. And I think it's worth asking for those things. It's a kind of a complicated thing because what you can do on a rental property, it depends on if it's your property or if it's the landlord's property. So there may be several different parties that you need to talk to in terms of getting accommodations and then who's going to pay for them. And so what I would say is if you would like to discuss it, I'm happy to talk with you, could give me a call. And I think that may be the most effective way given the time constraints.
Thank you, Debbie. Unfortunately, we've gotten to the 4 o'clock mark at this time, and this ends today's presentation. As we've said, we will get back to individuals who have put questions in the chat box after the webinar is completed. I would like to thank all of our speakers for today's discussion, and I'd like to thank all of you for attending this afternoon. So enjoy the rest of your day and have a great weekend. Thank you.